Have you felt like your answers in law have always fallen short? Perhaps this is what's missing. Hi, and welcome to the Law Simplified. I'm Shaveen Bandadnayaka. In the past 8 years of doing one-on-one masterclasses and teaching students from all around the world, and having marked nearly 1,000 answer scripts, I have come to realize that more often than not, the failure of students to achieve the grade they feel they deserve in an examination context is predominantly due to the disjointed nature by which they articulate their responses. Most essay or problem-based scenarios anticipate that a student goes above and beyond the mere substantive law that has been taught to them, and they showcase their personality to an examiner. More often than not, I have mentioned on this very YouTube channel, as well as the different platforms that the Law Simplified is disseminated on, that a law degree tries to determine not what you know, but how you think. And as a result, anyone with this particular qualification, be it a diploma in law, an LLB, a GDL, or a higher qualification such as an LLM or a PhD, often separates a particular class of persons from others. Not because of what they know, but how they think and how they assess the world around them. As a result, your responses in law must be a reflection of your thinking, of your personality. This video is meant to give you a broad-based understanding of a technique that I have developed and have communicated and trained my fast track and masterclass students over the past several years to implement and succeed in their examinations. Let's have a look at how this technique can be implemented into a scenario-based question, in this instance, one of negligence in tort law. Let's first have a look at the scenario before breaking it down and applying the stitch technique. Sheila, who lives in Australia, came in January 2019 for a 2-month visit to her daughter Ruth and her family in England. She had not seen them for 3 years. In February, she went to the children's playground run by St. John's Church with her 6-year-old granddaughter Linda. The local council, the Miserly District Council, had a statutory duty to inspect such playgrounds, but had not done so for 6 years. Linda played on a chute, but on one descent her foot became trapped and she suffered a nasty gash on her ankle. Sheila managed to extricate her and took her to the accident and emergency department at the Miserly Hospital. Sheila has suffered a recognized psychiatric injury. Advice as to any claims in tort by Sheila. Pause the video here if you'd like to go through the scenario or the fact pattern once again before proceeding. Right. Now that you had a chance to look at the scenario, let me first outline the fact that this is an extract from a much longer scenario, in an examination scenario at that, and there are a number of areas in the law of tort that require discussion for a question of this caliber. But for our own purposes, in terms of understanding the stitch technique, I'm going to look at only the aspects relevant to a secondary victim or psychiatric injury. Now, in order to do so, it's necessary to have a brief outline and an understanding of duty of care, specifically in relation to a secondary victim or a duty owed by a defendant towards a secondary victim. Now, this video is not long enough, nor is it detailed enough to go in depth into duty of care. If you're interested in such a lesson, have a look at the online law school platform or some of the videos available on the YouTube channel as well. But for now, in order to understand the substantive law that applies, we need to articulate, or we need to recognize the fact that this question, at least the extract that we are looking at, relates to duty of care, and more specifically that of psychiatric injury suffered by Sheila. Now, in terms of a secondary victim, one who has suffered psychiatric injury, the very first thing that you need to understand is the distinction between a primary and a secondary victim. White and Chief Constable of South Yorkshire, as a precedent case, illustrates that a person who is a secondary victim is someone who has not suffered any physical injury, nor was in any danger of suffering any physical injury, but has only suffered psychiatric harm, having witnessed something that has happened to the primary victim. Now, by saying such an outline, what you should then gather and understand is that the determination of success or failure in terms of a secondary victim would be based on where you were and who you are. For this purpose, we need to understand that Sheila falls into the class of persons referred to as friends or relatives. Now, there are a number of cases which are relevant to us, but two in particular which we will look at for the stitch technique is Alcock and Chief Constable of South Yorkshire and McLaughlin and O'Brien. Predominantly, the case of Alcock and Chief Constable of South Yorkshire established the principle of nearness and dearness. Essentially, it suggested that in order for a secondary victim to succeed in a claim against a defendant for psychiatric harm, he must not only be proximate in terms of location, in other words near, but also sufficiently emotionally close to the primary victim. In other words, Sheila must not have just seen what happened to Linda, but also be emotionally attached and close to the primary victim, in other words, Linda. Having said that, between the two, going a step further, the case of McLaughlin and O'Brien established that although we look at nearness and dearness, proximity of location, as well as relationship as being equal to one another, for all intents and purposes, the law is willing to forego the absence of the secondary victim at the location as long as he or she is sufficiently close emotionally to the primary victim. This is where we are going to apply the stitch technique to. In other words, the way in which we are going to articulate an interesting argument to try and recognize that there is this distinction and whether it in fact applies to Sheila or not. Having understood the theory and the scenario that we just looked at, consider this particular circumstance. The fact pattern or the scenario suggests that on the one hand, whilst Sheila was present and is the person that evidently managed to extricate Linda from the accident, from falling over in the chute, she has not seen the granddaughter in over 3 years. The granddaughter, Linda herself, is 6 years old. In other words, whether there is a sufficient bond between the grandmother and the granddaughter is something that needs to be discussed. Now, this is an aspect in this question that would come up at the very end. In other words, when you discuss a fact pattern of this caliber, you'd start by looking at the distinction between a primary and secondary victim, followed by the requirements in order for a secondary victim to succeed, then apply that to the scenario, and then present an argument that may indicate a situation in which the secondary victim might fail. The stitch technique is used to try and weave together, so to speak, these aspects: the law, the distinction, the facts, the application, and the argument. The next time you look at a question, be it in tort law, criminal law, contract law, or any other subject for that matter, try to weave a story. Don't just stick to the facts and the law, and not even the application of that, but try and present an argument which is interesting to the examiner. Remember, this technique is meant to help you look at a scenario, the facts, the substantive law, and the arguments differently once presented during an examination situation. But the way in which you articulate your response, the style of writing, should be unique to who you are, to your personality. If you'd like to get an understanding of the law, how to read a question properly when presented in an examination, break it down and articulate responses at a first-class level, I'd highly recommend having a look at the comprehensive online law school platform, which is complete with pre-recorded theory, tutorial, and workshop lessons spanning 14 modules in law. That being said, until the next time that we meet, have fun, stay safe, and as always, obey the law.